All right, well, welcome to our CMU. We are talking about bad apples today, and Anne is going to tell us all about this bad apples.
Yes, a fun topic. And just the disclaimer, this session is being recorded for the benefit of Collins team members, those that are here and also not here. Please don't forward this to anyone outside of Collins, including board members. Because we have no way of controlling what they do with these type of things. Obviously, if you guys need legal assistance or an opinion on a particular topic or issue, please reach out to our office or the association's general counsel if they're not with us. So with that, we'll get started. Good afternoon, everybody. I think everybody, all familiar names on the screen so far for those of you who I have not met. My name is Anna Cunha. I'm a partner at Angius and Terry in Walnut Creek. We are a full service law firm specializing in community association law. We deal with a lot of bad apples. Some of them are yours and your associations. And this is just a back to basics discussion about governing document enforcement and the steps for dispute resolution. So many of you who I know are very experienced dealing with these. It'll be a refresher, and you can share some of your unique experiences and pointers for everyone's benefit. Because usually our office legal counsel gets involved in a limited number of these situations, you know, when it becomes necessary, but a lot of it you deal with on a day-to-day on your own. So we'll get started. All right. Okay. So again, we're talking about enforcement. So CC&R rule and HOA rule violations, not just CC&R's, governing document violations mainly. And this is just an overview of kind of the main themes to think about when you're dealing with owners that are in violation of the documents. It's going to be a cost benefit analysis for the board. So always remind the boards, because you can go after a lot of people for a lot of things, but in the end, is it worth it? How many, you know, so part of it is who's complaining, how many people are complaining, what is taking action going to cost. So, you know, so you have to pick and choose. You can't, you know, just tow everybody in violation. You have to go through steps because there's costs involved in enforcing the governing documents. Involve counsel. You know, when you're dealing with a particularly difficult or litigious owner, where you should know and be able to identify where you need counsel involved early on an issue, especially if, for example, previously they filed a lawsuit against the association. If a different new issue comes up, you know that you'd have to be very careful and may need to involve legal counsel much earlier on than you normally would. And you know, in some of your boards, they are probably hesitant to get the lawyer involved right away because of costs, which yes, it costs money, but you know, often it is worth it to get counsel involved early on so that you're not involving them after the fact, after you've already been sued or after you can't unwind and undo certain things. So that's the benefit. You know, the advantage of getting legal involved early on is to avoid a potentially bigger legal issue. And as always, whoever you're dealing with, but particularly when you're dealing with the difficult and litigious owners, it's going to come down to your documentation, things that are in writing, in your personal records, and also what is communicated to that homeowner. And then the last bullet point, always make sure you're sticking with, following statute, the Davis-Sterling Act, but also the governing documents of the association throughout the process, because sometimes that's forgotten and you get caught up with just doing things because your boards are directing you to do something without kind of slowing them down and taking into consideration what's in the documents, what's in the law, or consulting with counsel first before doing what the board is ordering you to do. So dispute resolution process, what do you do? This is the general process for if someone is in violation. You may have people walking the site and noting down potential violations. You always want to start with a courtesy letter and give the homeowner a chance to correct the issue on their own without having to go through the next steps. And that's important. It's good policy, which is a reminder, if your association doesn't have a fine and enforcement policy, make sure they have one. Election rules and fine policies, you would be surprised how many associations don't have it, and they're required to have those two things. So audit your new accounts when you inherit them. Make sure they do have those policies. So starting a courtesy letter, number one and number two, I think a takeaway message, because I've been seeing it more often. Please make sure you cite to the rule or CC&R provision that is in violation, that the person is in violation of. Many times you probably draft so many of these, or you have to draft a lot of these and get them out quickly. They don't cite the specific rules or provisions, and I have seen when they get legal involved, like I saw a letter saying you are something about the noise after 8 p.m. And that's what that person was being called to a hearing, but they didn't have a rule that says it's like noise off. I mean, it's common courtesy. We have to check to see if there were city ordinances that but I think the board just felt that was a violation, and the manager in that instance just put that in the letter without checking to see if there's even a rule that's in violation. You could have we relied on the nuisance provision basically, which is going to be the fallback, but it made it sound like they were, or I think the way it was drafted, it said you were in violation of HOA rules, and they just generally said that when there wasn't a rule. So you want to start with courtesy letter before you start going into the disciplinary hearing process. I think we're going to go through these, and I'm just talking and blabbing about each of these, but the disciplinary hearing process is probably where hopefully things will be resolved through fines or some other disciplinary action. But if it doesn't, then if it needs to be escalated, then you would go into IDR, or meet and confer. This is the informal meeting between the owner and a board representative. And then ADR, sometimes homeowners or managers use these two terms interchangeably. They're different because IDR is the informal meeting. ADR, or alternate dispute resolution, means either mediation or arbitration, where you're with a third party neutral, almost always someone who is being paid. So there are going to be costs involved. And almost always when you're in ADR, you should be, if you're not represented by counsel. And then, of course, litigation is the really the last step, the last resort. And that's sometimes associations have no choice that they're in litigation, but that should be considered the very, very last step to getting someone to comply. Okay, I think I was like talking about a lot of these points for your courtesy letters. You probably have a template or a form. If you do, just make sure that in that template or form for Collins, make sure that you are directing the manager or your assistant to identify which CCNR rules or CCNR provisions are being triggered by certain conduct. And the idea, again, is to bring the issue to give notice to the owner who you would be sending these violation letters to, even if it's the tenant who is engaging in conduct and violation. You know, the association has privity of contract with the owner, not the tenant, and you want to hold the tenant, the owner responsible for the actions of their tenant. Sometimes you need to you may need to send a copy of a violation letter to the tenant, but the idea is you want to be directly dealing with the owner of that property. This is also going to be important. Your violation letters is also or it could be the beginning, or it's part of the written record. So if this was escalated to litigation or something like that, this is all part of what a judge or a jury would review. So keep that in mind. It is important. It's an important communication. It should be on letterhead. And it should give the owner a reasonable amount of time to comply. So if it's an architectural violation and they need to remove something major, like say a gas line that they installed without permission, I don't think it'll serve anybody to give them 5 days to do something like that. So keep that in mind. You want them to comply, and you want to give them, meaning the association and the board, want to give them a reasonable time to get that work done. So keep that in mind. I think it should be part of the HOA's process of having these warning letters. But if it is not, some associations have in their CCNRs, or they have a written policy that requires a warning letter. So just keep that in mind. If it's not part of your normal process, then it should be to check, you should check the governing documents to see if that's required before you call someone to a hearing. And then also the follow-up, a lot of times you put a date and you require someone to fix things within a certain amount of time, or to get them to comply within a certain amount of time. You would want to calendar a follow-up, so to see if you need to send another notice or call them to a hearing. And that's something, that if it doesn't get done, you end up getting, the board is relying on you to make sure it's addressed. So it's important to calendar that follow-up and not just, cross it off the list after the notice is sent. Okay, and then the hearing, you all know you have to give notice to homeowners of disciplinary hearings. Under the code, it has to be at least 10 days before the hearing date that the notice must go out. But please check the governing documents, because some of them require, I've seen 15. And there may be some out there that require even more notice. So make sure you give as much notice as possible in compliance, not only with the code, but also if the governing documents for that association has a longer time notice period, you want to comply with that. It should have, so under the code, it has to have the date, time, and place of the hearing, what issues will be discussed. So basically what the violations are. And it's important to include all of them because the board can't impose discipline on something that was not raised in the notice technically. So if, for example, you are noticing a hearing for a member who did certain things on these dates, technically that is only what you are going to be discussing at the hearing and imposing discipline for. Obviously, things, between the time you send the notice and the hearing, other things come up, and it's it's probably appropriate to discuss them, but you can't impose discipline technically on the new things. You would have to either revise the notice and postpone it if there isn't enough time to give them the notice that's required under their documents for the code, or you have to just go forward with this hearing and then set another hearing for the subsequent violations. So that has to be set forth in there. It's important to have the facts in there because, like I said, this is going to be your written record. Later on, when there's litigation, you may not be managing this account. It may be someone else, and people will need to figure out what exactly the issues were previously that weren't addressed. So it's good to include the basis for the violation. Again, the CC&R section or sections that are in violation, or if it's a rule or policy violation, then identify which policy or rules are in violation. And then the last bullet point in this slide is really important. If you're going to issue a fine, then it should say that on the notice that the board is considering issuing the maximum fines, or if it's a dollar amount, the dollar amount. If I had an association where they wanted to take away a member's right to use the boat dock, which is a common facility, but we couldn't do it the first time around because the notice didn't say anything about that. And they didn't have a fine and enforcement policy. So it was in their CC&Rs that that the association could take away that privilege, but that homeowner wasn't specifically notified that that was on the table for that hearing. So make sure, if you want to lump it all, the board doesn't have to impose all those things, but members need to be notified of what the potential consequences are for the violations that'll be discussed at the hearing. So there's the time frame that you need to make sure you're complying with as far as issuing the hearing notice, and then the hearing, which is usually 10 days. That's the code. In most governing documents now have 10 days also. But I see some older ones that say 15, and then there may be some that have more. And then the notice of decision, where you inform the member that they'll be fined, or whatever the discipline that's being imposed, or if the board decided not to take action, they need to be notified under the code 15 days after the hearing. And again, check the governing documents to see if they have a different time frame. But if it's silent, then it's 15 days after the hearing, calendar days. So the decision of the board must be reasonable and not arbitrary and based on evidence. A lot of it is going to be subjective, right? Because a lot of it, For example, nuisance violations, was the person being too loud? What were the actions a nuisance? A lot of it is going to be subjective, but that's going to be what the board is evaluating, the facts. If it's a he said, she said situation, then they have to weigh the credibility of who's saying what. That's all going to be part of it, and it should be outlined. Ideally, all of the basis for their decision is outlined in detail in the notice of decision. So later on, if future boards or the homeowner or it's in litigation questions why the board imposed that type of discipline, then it's clear. The explanation is in the documents. Oh, and this is where you would put, you know, if they're being fined or if it's a reimbursement assessment, the dollar amount they owe. You would, if it's a reimbursement assessment or a fine, you always want to include where they're supposed to send payment. And it can't be, if it's a reimbursement assessment, say, for example, for legal fees incurred, it can't be to be determined or some kind of surprise number. You want to make sure that amount they have notice of, even if it's just a range. You need to provide notice of that in the notice, and then specify in the notice of decision what it is, how much they owe, what it is, you know, if it's a common facility they can't use anymore, what that is. So forms of discipline, we talked a little bit about these. The most common is fines. That's the main power boards have on their members to get them to do things, are fines. And what do you do when a homeowner doesn't pay the fines and they keep doing what they're doing? I always suggest, you know, obviously lawsuit, but a small claims action. And it's not so much to get money. That shouldn't be the goal, is to get money. The goal is to, but if it's under $5,000, you can do a small claims action. You don't need a lawyer to go to small claims court. If they want management to attend, I'm sure you guys charge extra for that. It's less than sending a lawyer there. And the idea is to just put pressure on the homeowner to comply. And it's not to get your $5,000, the board to get their $5,000, but to get them to just fix whatever they need to fix. So fines are important. Attorney's fees and costs. You would want to make sure that that's permitted in the governing documents. I have seen some where that is not recoverable, that the association can only recover costs incurred from making repairs, but not legal fees or other costs. So make sure that's there. And then you can also restrict access, or boards can restrict access to common area facilities like the pool or the boat dock or things like that. What the associations can't do or take away starting in 2019, even though a lot of older documents, governing documents, CCNRs and bylaws say you can suspend a member's voting rights or disqualify them from serving on the board. You can't do, associations can't do that anymore. So yes, you can end up with board members who have unpaid fines on their account, or board members actively in violation of the governing documents because of how the current law is written. So yeah, any questions about the member in good standing? That usually have to go through a hearing process to take away a member's good standing status. But that just basically says they may not be eligible to serve on the board. And the good standing is now limited to payment of regular and special assessments, and not compliance with governing documents. You can't, associations can't restrict access to common area in general. Sometimes there's, you can't prevent them from having access to their home, like, ingress, egress to their home. And also, members have easements over the common area in general. And so that's something you can't take away, but privileges to use certain amenities of the association can be taken away. That's not a necessity for living to be able to use the swimming pool. So that's something they still have. We talked about the fine policy, the importance of that. So yes, make sure your association has a fine policy. And unfortunately, if it's old and it says they can only fine $50 per violation, which is really nothing, they'd have to revise the policy, or if it's in the CCNRs, they're kind of stuck with that, because you can't impose something more restrictive by rule and not amend your CCNRs. So keep that in mind. Disciplinary actions, fines, it must be reasonable. Homeowners must have notice of what those amounts can be. So that's why you have to have that a fine schedule in your fine policy, which, by the way, is also part of your annual disclosures. So check that, because I have seen some associations don't have a fine policy, even though it's supposed to be part of the disclosures. If you do manage some commercial associations, also beware. I dealt with it recently. Some commercial associations are subject to Davis-Sterling and require certain things like a fine policy or annual disclosures and things like that. So, and then there's sometimes, oftentimes the fine policy talks about a certain type of fine for a first offense versus a second offense. Hopefully it defines, what is a repeated offense, what is considered a second offense versus a repeated offense, all those things. And if it's vague or unclear in the policy, then it probably needs to be cleaned up. Again, repeat violations and continuing violations. We often get asked, if a homeowner continues to do the same thing over and over again, do we have to keep calling them back to a hearing? And if it's kind of unclear, then the answer is going to be you should, because it might be a separate violation and not a continuing one. For a continuing violation, I always the example I get is like an architectural violation, something that's in place and there, and it's just continuing to be there. But like a repeat violation is someone who parks in guest parking. It's always a different instance, but they keep on doing the same thing and violating the same rule. But it's different instances when they did it this day versus that day. So those will be repeat violations. It's not a continuing violation. If they left their car there in place and never moved it, that might be a continuing violation. But if it's something they just do all the time, but there's separate instances that can be challenged, then that has to be treated as a repeat violation. And unless your fine policy allows for fining without calling someone to a hearing for a repeat violation, you should call them to a hearing or schedule a hearing, but list all of those instances. And most fine policies allow for a fine for each offense. So if they parked in guest parking on these 10 dates, the board may be able to issue fines for each of the 10 offenses. So that could be, 10 times. So work with counsel. If this is where a lot of times members challenge that they weren't properly given notice and that you were just putting fines into their account without them having a chance to challenge it. So it could be tricky. And this is where, if you're dealing with someone like that, you would want to work with legal on that. Let's see. Okay, so IDR, internal dispute resolution. So this is, there's many situations where IDR is appropriate. But in terms of a member who continues to violate the governing documents, if fines and imposing other disciplinary actions just isn't working, then you would want to try and have them sit down with a board representative. Encourage the board to designate someone who's reasonable and who's not going to unnecessarily escalate things, someone with a good temperament for doing this, to meet with that homeowner and help come up with a solution. That's the idea of an IDR. Under the code, the association can always request an IDR, but a homeowner can refuse to meet with the board representative in an IDR. So, but the other way around, if a homeowner requests IDR with a board representative, the association can't say no. They need to schedule an IDR within a reasonable time frame. This is IDR, sometimes called meet and confer. The code has default procedures. If the association doesn't have one, then the code's civil code's default provisions will apply. The association can't charge a fee for this under the code. The association can't require counsel to be present, and I actually advise boards to not have counsel present. Obviously, if the homeowner says, I want my lawyer there, then the board should also have their lawyer, the association's lawyer, present. So you're on an even playing field. But the idea, I discourage legal being involved because it's at this stage, it's usually beneficial to have a more informal meeting to work things out. Notify counsel, because what I do is I give kind of like a checklist, and I also forewarn the boards that if you're going to agree to something and you're putting things in writing, always put like a caveat that says this is subject to review by counsel. Because I have seen boards agree to things that are in violation of the governing documents or in violation of Davis-Sterling. And then we have to tell the homeowner that, the board said yes, but they really can't do that. And then it just, it doesn't help. So just, make sure if the boards are going to do that, putting something in writing, that they make it clear that it's going to be reviewed by legal, just to make sure that it's okay. Okay, we talked about these things. Location and when it's scheduled, it just says, the code just says it has to be, within a reasonable time. It's in a place that's mutually agreed to. So, I think before there was always an issue, we want to meet by Zoom and do the IDR by Zoom. And then the person says, I don't want to. They have to try and come up with a solution to that, because this isn't a board meeting where the board gets to dictate where it is. They have to work with the homeowner to figure out where and when to hold this meeting. I think we talked about the no fee. Okay, we talked about that. Okay, we talked about an attorney, that they can have an attorney, but generally not advisable. And if the association, for example, has their attorney present, even if the reason is because the homeowner is insisting that their lawyer be present, they can't charge the homeowner, get reimbursement from the owner for having their lawyer present. Having their lawyer present is a benefit to the board and the association. It's not something that they are legally required to. They technically can meet with the homeowner and their lawyer, but that's, of course, not never a good idea. Associations that have a lot of issues, difficult owners, a lot of legal issues. If year after year they're going over their legal budget, you need to strongly recommend when it's budget season that they need to be more realistic about that. That's just an aside, but you will have those associations that, only put like $500 as their legal budget for the year, but they have such difficult homeowners that that doesn't even make sense. So keep that in mind. If they don't have an IDR policy, then they should adopt one. But if not, many associations don't. And you're required to put it in the annual disclosures. A lot of associations just go with the standard IDR process that's in Davis Sterling. And if your association doesn't get a lot of IDR requests, that's probably fine. But if they do and they want to be able to control certain things more, then they should adopt a policy. Just a few issues. Can the entire board meet with the homeowner? I think technically yes, but the idea is to de-escalate whatever the situation is, and oftentimes bringing the entire board or having the entire board present, unless requested by the homeowner, but that defeats the purpose of the IDR and the effectiveness. If the homeowner brings an attorney and didn't notify the association in advance that they were, then we always recommend that the board stop the meeting and reschedule so that they can have their attorney present there. And that wouldn't be seen as unreasonable. It's only fair for both sides to have their counsel there if the homeowner is insisting on having theirs. And we would say the same if sometimes we get asked to attend an IDR. I always tell boards, well, we should tell the homeowner. And give them an opportunity to bring their lawyer if that's what they want, because the last thing you want is to have it scheduled and ready to go, and then the homeowner is like, oh, I didn't know the HOA's lawyer is going to be there, so I don't want to go forward. And you can't force them to do an IDR with the HOA's attorney without them having their attorney there. Multiple requests for IDR. Every once in a while we see these. And it's just like records inspection requests. It can be used as a tool by homeowners to harass HOAs and managers. You just want to document, that's why it's reasonable to ask what issues they want to discuss in IDR. And if you've already had an IDR in recent months about the same topic, work with counsel. But I always say, if we can document that we've already provided this, we had a long meeting and we've already complied with that request, you may be able to justify denying the request for IDR. Same thing for documents. If they just requested, there's no timeline in saying that the homeowners only get to ask for records one time. If they want to ask for them every 3 months, they have the right to. or at least I would just provide them with documents they haven't received yet, but not everything every 3 months. So you would want to make a record of what, when the IDR happened and what was discussed. And if the association can make the argument that you already had an IDR about those specific topics, then you could probably say no to another request. ADR mediation, under the code, members can request a request for, it's usually called a request for resolution. Sometimes CC&Rs have specific forms or a format of what members are supposed to do when they want to mediate. Again, this is with a mediator or an arbitrator. And under the code, both sides pay the mediator's fees equally and get to choose who that mediator or arbitrator will be. It is a prerequisite for any party filing an enforcement action. So I remind members who are threatening lawsuits against the association when they say, well, I'm going to file my lawsuit next week if you don't do this. Sometimes it's a good idea to remind them, like, well, by the way, under the civil code, you're required to do a mediation first. Otherwise, we do a demur if they didn't. And what we have seen is judges will usually basically pause the proceedings and then tell the parties to mediate. But it's good to slow things down a little bit and give the parties a chance to try and work with a mediator to see if things can be resolved. The request for resolution form, or anytime you see a member saying, I want a mediation, I want a ADR, sometimes they really mean IDR. So I would get clarification. Do you want ADR, like mediation with a third party neutral where you have to pay for that? Or are you talking about IDR, internal dispute resolution, a meet and confer with the board? And a lot of times they really mean IDR, but I get that confirmation. But anytime a member asks for mediation, confirms they want mediation or ADR, or you get this a letter that says request for resolution under 5900, then notify the association's legal counsel, because there are timeframes of when to respond to it. And if the association fails to respond, I believe it's 30 days. If the association doesn't respond to it, then they get their green light to file the lawsuit. And they'll say we considered our obligations under 5900 complete. So you don't want that. So yeah, those have a statutory deadline. So those are important. Yeah, under the code, once the association receives a demand for mediation or request for resolution, they have the association has 30 days to respond to it and accept mediation. And once you accept or agree to mediation, you have, I believe, 90 days to complete the mediation unless both parties agree in writing to extend that time period. A lot of mediators these days are also doing mediation by Zoom. There's benefits and there's benefits to that, but there's also drawbacks in doing that. So yeah, work with counsel for to strategize on the best way to mediate a dispute. These processes have to be in your annual policy, so check on that. You guys probably have a standard form for that, so there should be at least the provisions from the Davis-Sterling Act that's in there. Just so you know, the difference between mediation and arbitration. Mediation is non-binding. Arbitration is, think of it as a trial or a judge making a decision and telling you, ordering parties what needs to happen. A mediation is The third party neutral works with the parties to come up with a solution that they both voluntarily agree to. And a good mediator will basically tell both sides that your case isn't great, you might as well just settle. But then, you know, it's up to the parties to actually do that. Whereas an arbitrator decides an issue like a judge does. And so it's less common. It's very expensive. It's treated like almost like a trial. And you go through a formal process of exchanging documents, of filing pleadings with the arbitrator. It's not very common. Usually it's done in lieu of a lawsuit. So I think I would never recommend doing arbitration before mediation. Number one, the costs, and number two, you want to try and work things out on your own, or at least with a mediator, and not having an arbitrator order parties to do something. And that because the arbitrator, their ruling is enforceable. It's like a judgment against the association. So it's a very, very serious proceeding and not one you would take lightly. And of course, litigation, it's always there, which is good. It's always there to remind homeowners of the board's option to litigate an issue and demand attorney's fees if they prevail. But, you know, it's expensive. There's risks involved. Even in a slam dunk case, you never know what a jury or a judge is going to do. And I think people not just expensive, but I think boards sometimes forget that they have to pay for this lawsuit as you go. It's not like if they're initiating the lawsuit, it's not like defending a lawsuit, which, you know, most of the time the insurance company will assign the association a lawyer and pay for the lawyer's fees. If the board is initiating a lawsuit, they have to pay for it. So they either have to have money in their operating account or be prepared to specially assess their members. If they're going to borrow from the reserves to file a lawsuit, then they need to have a plan to pay that back in a year or close to a year. They can extend it with notice, and they will have to notify their members about this lawsuit. So it's not something they can do secretly. They will have to notify members because it's the members' money they're using to litigate. So yeah, they'll most likely have counsel involved who will guide them through the steps of notifying members and how to fund the lawsuit, whether it's worth it, the strengths, the weaknesses. And sometimes, you know, in situations it is worth it. Like, I think one where it is, if you're in the situation, it's almost always worth it. If you're dealing with an access issue and there's emergency repairs that need to happen and you can't get access to a unit, almost always that is a justified cost because you need to get in, and a lawsuit for failing to complete repairs is going to be a lot more than going in to get an emergency injunction to get inside a unit. But otherwise, breach of contract against vendors, homeowners' failure to comply with the CC&Rs or HOA rules. Those are the kind of things that, those are, you know, those are very important and potentially very expensive options to just go in and sue the person. And I also warn my clients that when you file a lawsuit against a homeowner, they will likely sue the HOA back, even for something that's meritless, right? And even if the association says, oh, okay, fine, just kidding, we're going to dismiss our lawsuit, that homeowner doesn't have to dismiss their cross complaint. They could keep it going. So if you're dealing with crazy, it's sometimes they need to understand that the person can just, it could backfire. And that happened to in one of my associations 2 years ago, and the association ended up spending over $100,000 on the lawsuit because the homeowner was threatening to file a cross complaint, but ended up like doing a bunch of records inspection requests and threats and all these things that racked up the association's legal fees that they were paying on their own. So so that's something to keep in mind. So it's not something that should be taken lightly and jump into. And to wrap up, yeah, complying with the governing documents, it's important. Always start with a warning letter, a courtesy letter. Get, hopefully the owner will comply on their own. That's always the best resolution. For disciplinary hearings, check the documents and comply with the timing of notices, the fines and disciplinary action that's imposed. Make sure that's supported by what's in the documents. Consider ADR mediation if, after meeting and conferring or the homeowner won't agree to meet and confer. If that doesn't work, then it may make sense to pay a mediator to resolve a dispute. And I've seen that oftentimes for crazy homeowners, it helps because they feel like they're being heard by a judge or like some third party who will do a good job with listening to their issue and agree with them a little bit, but then tell them they're crazy. And for some certain types of homeowners, I even recommend to boards to that we retain a retired judge as our mediator because they're, very judgy, like judgy. They're judge-like, and it makes the other party feel like they are being heard by a judge. And that sometimes is what they need to hear what our office, what the management office is saying, but coming from a third party, it is often helpful. So again, cost is a big consideration in all of this. Your boards want to, make sure they're doing their job, making sure everyone's complying with the rules, but there are costs involved in doing that. So that should be always part of the considerations. All right, I think that is the end of that. Does anybody have questions or difficult disciplinary situations you're dealing with, Melanie?
Yeah, I had a question. I've seen a few homeowners associations having policies that they automatically fine homeowners for certain violations. And I know that you went through the whole notice process before and after hearing to apply a fine. But my question is there any type of fine or any kind of argument we could make that automatic fines are applicable and are enforceable?
I think other than delinquent assessments, which should be in the CC&Rs, basically the penalty for that. I think all the others are subject to challenge because they'll always say, I didn't do that. I mean, where do they get to say I didn't do that? I guess if you have you can have photos, but the way at least Davis Sterling and the that might even be in violation of their governing documents, which say that talks about like notice and hearing. And that's the idea of due process. So unless that's actually in their CC&Rs, so unless, that's the answer to your question. Unless whatever it is in the CC&Rs, that's very dangerous to say, well, we properly adopted a policy and circulated it for membership comment period. But it's not, maybe they've gotten away with it for years and nobody's saying anything, but it only takes that one homeowner to say something, and I don't think that's an invalid argument that that's not proper.
Okay.
Yeah.
Great. Thank you.
That's a good question. Do you remember offhand, Melanie, what type of violations that?
I unfortunately have seen it with a lot of associations. I think the one that comes to mind is like garbage can violations. If they leave their garbage cans on the curb longer than what's applicable, like 48 hours or whatever after pickup, that they automatically get a fine. And it might be a small fine of like $50. And maybe that's why some of these associations have never been challenged.
Yeah, that's what I was going to say too. I'm like, if it's something that can be documented by photo and it's a small enough fine, they could probably get it. I think they're just getting away with it. I don't think that that's, totally compliant with their documents, but yeah, obviously the bigger the amount, the more they need to cover their basis.
So the recommendation would be to have the manager revise that policy that automatic fines are not just applied, that you actually go through the notice of hearing and result of hearing process.
Yeah, yeah. And if they say, no, we've been doing this, and they'll tell you, no, we've been doing this for years, and just say, okay, let's just have legal look at it and confirm. And then and maybe, we'll weigh the risk and benefit, and they'll say, yeah, okay, technically it's not okay, but it's such a small amount that we'll take a risk. But then at least that's the board taking that risk on their own, and it's not, you properly advise them basically. And that's the same thing what their lawyer will say. I properly advise them. If they want to take the risk, then they're doing that.
Okay, thank you.
Yeah. Jessica?
I have a similar question, which may have a similar answer to what Melanie asked. So what if they go through a hearing, and in the hearing, the decision is that let's say that for that particular instance, it would not be fined, but moving forward, should the violation happen again, then they would automatically be fined. So they already went through, the whole documentation, violation, hearing, but the decision at that particular hearing was that they would not be fined, but if it happens again, that they would automatically be fined. Is that okay?
Yeah. My answer. It's because whether or not whatever it is that they did, say parking. I see this a lot with parking, like someone like a chronic parking violator doing it, and the board is tired of, like, it's a long process, right? It takes like almost a month to go through this process each time they keep doing it, and they want to automatically fine. It's just, the problem is you issue a fine and the homeowner never got to say, that wasn't my car. I didn't do that. Or, that was 5 minutes, whatever it is, whatever their excuse is, they don't get to respond. Again, if it's like a $10, whatever, a $50 fine, it's probably, they could probably get away with that. And it's in the notice. So at least that gives the lawyer something to argue with. But if it's like a large fine, that's where you can't just, put that on without a hearing and giving them a chance to say something, even if the board is not listening. It's just kind of that process that they got to challenge it if they were going to.
And just to piggyback on that, though, wouldn't have they had the opportunity to challenge it during the original hearing?
Well, it sounds like a different event, right? Or if they do it again, like they have to be able to challenge that instance, which sounds like, I guess I'm thinking of they're not doing it, and then they're going to do it again in the future. They're going to do something in the future. Or are we talking about something that, like, okay, you're in violation, you're not going to be fined, but you need to remove this, whatever it is that you installed improperly within 10 days, or you'll be fined? I think that might be one of those situations where, like, okay, it's 10 days, it's still there, so you're going to start getting fined. But if it's like, next time you park in guest parking, you're going to be automatically fined, that's the problem, because that's a different event that they're going to be fined for. Similar it's the same violation, but a different event that they don't get to challenge.
Okay, so the more conservative approach would be, or even the more legal approach, I should say, would be to have a whole nother hearing for that second occurrence, even though you told homeowner, if you do this again, you're going to get fined.
Yeah. Yes. Yes. Yeah.
Okay, and it looks like Nicole put something in the chat. And my laptop is so small.
Sorry. So I was just asking about fines in advance. Like occasionally we have people that habitually don't comply with certain things that are between $50 and $100 fines, and the board will grant them like 30 days to put in the architectural application. Otherwise, they'll fine them for the violation. Is that not a good practice for things like that? Or I mean, we have the habitual offenders where we've gone up the fining policy to that, $500 threshold for the same violation.
Yeah. And I think the architectural, like if it's something that was there at the time of the hearing, it was all discussed, they had a chance to be heard on that thing that happens to not have been fixed by, I don't know, 30 days after the hearing like they were supposed to, that's okay because they've already been heard. But if it's, I think the issue is for repeat offenses, not
okay. Recurring things like parking.
Yeah.
And trash cans, those fines shouldn't be held in advance. Okay.
Smoking, nuisance, noise, because those are the kind of things. I think it's good to say that you're going to automatically fine, but to actually do it, it's always safest. And so what we have done in those associations where you have like those chronic violators, like we had a smoking issue. So the manager we would just have like a log of the days of complaints. And then like every month we would schedule a hearing about these 17 instances of smoking. And then they would fine for each. And then the next month we would do the same. And this time it's 25 different situations. And in that instance, they wanted to do it automatically, but I advise them against it. They should be able to challenge each and every time. So it just became an important thing to document. And then we would call him to a hearing regularly for that. And eventually he moved out. So it worked. It was a lot of work for everybody, but they got what they wanted, I think. So, yeah. Any other questions?
I just have one other comment about fines and small claims. You had mentioned small claims earlier. Could you maybe go into a little bit of detail about fines and what we can utilize small claims for?
Yeah, that's a good one. So like I said, fines are going to be the associations and the board's main tool for enforcement, and they should use it. So they should have a solid fine policy that has a big enough fine for it to hurt, but not too big. It can't be, $1,000 per violation, but whatever it is, not $50. That usually doesn't bother anybody or get them to change their behavior. But so have a fine policy, comply with it. And the idea in the back of their pocket is to notify the member that if they don't comply and with these unpaid fines, they are going to small claims court to collect on those unpaid fines. And in California, a corporation like the association, the maximum you can sue a person in small claims is $5,000. So if they have unpaid fines that are more than that, then they can just go after the first 5,000. There's a limit of how many small claims lawsuits they can file. I'd have to look that up, but they can't basically go after 10 people, or maybe they can. There's a limited number of how many small claims action a party can file, and then a limit on the small claims action for the person you're suing. But anyway, it's an important tool because nobody wants to be in a lawsuit, even if it's a small claims lawsuit. So the idea is, and this, it's still a lawsuit. You still have to serve papers and a complaint on the homeowner for the unpaid fines. But it's the complaint is very easy. It's fill in the blank. You guys can do it. And I'm sure it's not part of your management contract, so you would still charge for it. But it's pretty easy. And most of the time, the small claims judge will order a like a mediation or a meet and confer, or not a mediation or settlement conference right before the hearing, like at the footsteps or like right outside the courthouse. And you have an opportunity to settle with the homeowner, either for a smaller amount or some kind of amount, or to get them to comply or agree to comply with whatever the issue is. And then that settlement agreement would be in writing. You could tell the judge, or if you're working with a mediator that's there, they'll help you put that in writing. But the key thing is it is a lawsuit. So it is a lawsuit against that person just for a lesser than $5,000 amount. And it gives the association extra leverage to hopefully get compliance from the homeowner. So I think the fee for filing a small claims action is very minimal, like a couple $100. Lawyers cannot be present. Lawyers can help guide parties. Our office, we often assist with preparing a letter to the court with all of the evidence that we like to send to the judge before the trial date. So they have it all, and then the manager can use it as like an outline of their arguments, and it's already ready for you. But we can't present it to the judge. That would either be a board member or the manager.
Thank you. Does anyone else have any questions before we wrap up this afternoon? All right.
All right. Well, you guys know where to find me. Anyone from my office would be happy to help with all of your disciplinary enforcement issues and any other issues. So feel free to reach out. We have our special low rates for new general counsel clients and also a free board training. So if your associations don't already have general counsel or need a new one, please reach out to any one of us.
Thank you.
All right.
All right,
Thanks, everybody.
Bye, guys.